Our next presenter is Ken Harper. Ken is a partner in the Menke Jackson Buyer law firm in Yakima. Ken's practice emphasizes municipal land use law and general municipal trial defense. This work regularly includes administrative and judicial litigation associated with retail, industrial, and residential proposals. He also advises clients in the areas of SEPA, the State Environmental Policy Act, and GMA, the Growth Management Act, compliance. Ken has over 17 years of experience in various facets of land use law. He has argued before the Ninth Circuit Court of Appeals, the Washington Supreme Court, and the Washington Court of Appeals. Ken is a 1995 honors graduate of the University of Texas School of Law and a frequent presenter for the short course on local planning. Please join me in welcoming Ken.
Thank you. I'd like to get a showing of hands. Who's got a law degree, whether you practice or not? You got a lawyer or a law degree holder? We got one. Okay. Well, Maury's already established that he's going to be the cool, fun professor. All right. Okay. So I'm going to yield that title to him. I'm afraid I'm going to be the mean, dreadful professor, and hopefully there'll still be some informational value that's conveyed. So the question is, what's this legal primer going to be about, and does it have to be dreadful? So what it's about really is putting in the minds of planning commissioners and elected officials and professional planners some of the thoughts of why land use planning in Washington works the way it does, why it looks the way it looks, and possibly how you can think about good planning as a form of economic development, or ED. Not ED that the doctor might refer to, but a different kind of ED. Now, why does it have to be dreadful? It just does. Now, I can't get away from that. We're going to have to talk a little bit about the Constitution. We're going to have to talk about some statutes. I think it was Winston Churchill who said something like, "To the British people, I offer nothing but blood, sweat, and tears." Well, the lawyer's corollary to that is, I offer nothing but suits and writs and fees. Okay, so that's going to permeate this talk. Is good planning can help promote economic development. Bad planning, bad permitting processes is a disaster for good economic development. It's a disaster for inspiring the confidence of the people who voted for you. It's a disaster for inspiring the people who come before you if you sit on a board or a commission. It's a disaster for promoting good spirits of cooperation and a sense of everything that Maury really talked about regarding healthy communities promoting jobs. Healthy planning certainly can promote jobs, but not when healthy planning grinds to fine dust in land use dispute. So let's get to it. We're going to begin with sort of putting things in context here. And for present purposes, putting things in context means backing up a little bit to understand where planning comes from. We're going to move from planning into permitting, and then we're going to talk about planning and permitting and economic development. And then I want to talk a little bit about how we sort of go from this minor key, the gloom and doom, to some practical things you can do to dig yourself out of the ditch. I'm going to throw you in the ditch, I promise you that. But I'm not going to throw you in the ditch without giving you some chance to dig out. So let's start with the beginning first. Planning exists in Washington, just like it does really anywhere else in the country, because we have passed laws that collectively state a preference to exert community preferences on how land is used, even when those community preferences regarding the use of land may actually intrude on a single private person's right to use the land as he or she otherwise would choose to do so. Right? I mean, that's a fancy way of saying that planning it's about a balance. It's about saying that community-wide, we're going to make some choices on how individuals use their land, on how private property owners use their private property. Well, that's a touchy subject. right? Because private property is, if you subscribe to the Lockean view, the Enlightenment, what our country came from, private property is a fundamental interest. It's a fundamental characteristic of what makes you an individual person, what gives you rights as a citizen, your property holder status. So planning begins with a couple of cases, and it begins not because it came down from Moses. It began with people making this decision, and then planning law is the extension of that decision over the course of nearly 90 years. So to wind the clock back a little bit, let me talk about a case, a Supreme Court case, Village of Euclid versus Ambler Realty, 1926 case. This, if you take Maury's cue, this is the beginning. In the beginning, there was Village of Euclid versus Ambler Realty, all right? And it was void and formless. In fact, not quite, but pretty close to it. Village of Euclid arose out of a concern of a little village, a little community, that was feeling the encroachment of industrialization from Cleveland. And the concern of the Village of Euclid was you've got this great big industrial complex in Cleveland just churning out factories and belching smoke, this whole Dickensian idea that we're all going to shovel coal and chain children to the shovel. Well, Village of Euclid didn't want that. And so when Ambler Realty decided that it wanted to when Ambler Realty decided it wanted to develop, rather, as industrial land, the Village of Euclid blocked it by rezoning Ambler's property. Okay. Rezone, pretty traditional form of planning at this day and age. Not so in 1926. There wasn't anything that had been tested that looks like a zoning ordinance looks to us today. Nothing like that had been tested in court, I should say. So the Village of Euclid has this idea that they're going to apply something called a zone to Ambler's property. Village of Euclid had six zones. That's it, total of 6. They picked one, and that one had the effect of suppressing Ambler Realty's industrial development aspirations. Couldn't develop as industrial land. Ambler Realty says, well, you can't do that to us. We own the land. What do you not understand? It's our land. We want to build a factory. Why can't we build a factory? Who are you to say that we can't? Well, they said, well, you can't. We zoned it. Okay, that goes to court. The trial court says, well, I don't understand the problem here, Village of Euclid. You can't tell them that they don't have that right. Without compensating them, at least. That's the Fifth Amendment, right? You got to pay. If you take an interest in land, you got to pay. But Village of Euclid, savvy village litigators, decide to appeal. And it goes to the United States Supreme Court, and the Supreme Court says, no, it is okay. That's a proper exercise of the police power to use this community planning preference to say, hey, this community has decided it doesn't want to industrialize this particular parcel of ground. Now, there was no claim that that zone was applied unfairly. There's no claim that it was done under cover of darkness or that it was done because it facilitated someone's own personal preference. The process, the procedure was fair. So the idea that was established in that United States Supreme Court decision is that if the process is fair, and if the zoning complaint is simply that we used to be able to use our land in a certain way and we can't use it that way now, if that's the problem, then that's not unconstitutional. That's okay. That's allowed. That's the exercise of the police power. There's nothing in the Fifth Amendment or anywhere else in the Constitution that says you can't zone. All right. With that minor foray into the world of planning, zoning explodes across the country. It explodes, and the repercussions make it all the way to the state of Washington, about as far as you could get. Oh, a footnote, by the way. Village of Euclid was concerned about the industrialization of Ambler Realty's property. For the next 50 years, Ambler's property sat vacant until a GM manufacturing facility went in. Okay? So I do think it's important to point out that you've got your zoning aspirations and then you've got your market factors too. And there's just so much that you can accomplish through zoning in the best of times. Okay, Washington picks up on that with the Planning Enabling Act in 1935, and the basic idea of the Planning Enabling Act is to do remarkable things like create planning commissions, planning departments. These things didn't exist. That's what's important to get across here. This did not exist before people decided to implement it through a collective political decision-making process. Official controls, the idea of a comprehensive plan. These are things that also spring from planning enabling in 1935 as kind of spiffed up in a 1958 subsequent enactment. So if you've got these beginnings, 1926, 1935, the next question is what's come along that's a little more current? You know, why does planning here in 2013, why does it not really talk much about Planning Enabling Act or Village of Euclid? Well, the answer is because so much has changed since the 70s with SEPA, the Shoreline Management Act, and GMA. You can probably safely relate the first of these, or the first two of these rather, to the environmental consciousness movement, the Earth Day, 1970, the sense that there can be political decision-making exercised regarding the environment. And you can probably also safely relate RCW 6440 to the sense that it had gotten too complicated. SEPA and shoreline management are complicated pieces of legislation, and the implementing regulations are a lot more complicated than the statutes even, all right? Well, 6440 is a cause of action. Okay, I got one lawyer in the room. What's a cause? A cause of action is a basis on which you can bring a lawsuit. So 6440 is passed by the legislature in 1982, and what it says is that you can sue a local government. Here comes some of the dreadfulness. You can sue a local government, and you can collect your attorney's fees for having to sue the local government, and you can collect damages against the local government in any scenario where the local government has acted maliciously or arbitrarily and capriciously in denying or delaying your permit. Okay, so think about what's going on here. We've got this constitutional authorization to zone, and Washington picks up on that, so we start zoning in Washington. We start overlaying these other statutes like SEPA, SMA, Shoreline Management Act, GMA, and it's getting to be a bramble bush, right? It's getting to be a thicket of regulations. And so the Washington legislature says, well, we're going to provide a remedy. So if the pendulum swings too far, if the government decision-making process is becoming too burdensome, we're going to give people ready access to the courts to bring a lawsuit and spank the government and get it back to where it should be and make the government pay the attorney's fees. Did I mention that? Fees. It's a big part of what matters in this field. So what we see here is the beginning of this balance, and then we see it sort of develop from one perspective, the Earth Day perspective, to the more clearly private property interest perspective behind 6440. What's really going on here is you're seeing an expression of this balancing act. And when you make decisions as planning commissioners or make recommendations as planning commissioners, you've got to understand that you're implementing a decision-making process that's meant to reflect this balance. Now, one way that's helpful in trying to capture that, nobody wants to have to go to law school to understand any of this. And so a nice pithy statement comes from this Norco King County decision, a Washington State Supreme Court case, 1982. It can be taken too far in too many different directions to take it literally. But what the court said there will guide you through a lot of the dilemmas that you may find come up in some of the rest of my talk or in your actual experience. What the court said there is that the basic rule in land use law, and this has been cited even since 1982, the basic rule in land use law is still that, absent more, an individual should be able to utilize his or her land as he or she sees fit. All right. That's tapping back into what I was leading off with. The basic idea is that you've got your property interests. That's what it begins with. You've got your property right. What the absent more relates to is the existence of a lawful planning goal or a lawful development regulation or a lawful permit decision that alters that basic position. So this isn't to say that zoning doesn't work or that critical areas buffers are outrageous. This is to simply say that if you're engaged in planning, if you're engaged in permit decision making, you got to understand what the baseline is. And the baseline that you're working from is the right to use the land as the property owner sees fit. Now, we're going to talk a little bit more about a few additional constitutional provisions, but I just want to come back and emphasize basic rule, okay? So as we go into the rabbit holes a little bit on some of these other things, you can usually work your way back out by keeping in mind that balance. Okay, there are a couple of things from a land use law point of view that are really key. A couple of constitutional things. One, of course, is the Takings Clause, the Fifth Amendment prohibition against taking private property without compensation. You can't do it, but it comes up relatively infrequently. It comes up if you're physically occupying property. It comes up if you've got a regulation that goes so far that it deprives the property owner of all use, right? But we've already established that you can zone, and that deprives a property owner of some uses, and that's not a taking. So to deprive a property owner of all use means you've got to deprive the property owner of all use. That's not that common. It can also come up in this funny scenario of exactions where you may be making a decision, say on a subdivision application or possibly a rezone, where in exchange for, say, a recommendation on a 6-lot subdivision, you ask for a signalization of an intersection on a 5-lane arterial at a cost of $350,000. Okay, there's not a lot of proportionality there. And particularly in state law, the idea that there has to be proportionality between the impact and the mitigation. You know, the proportionality between the 7-lot subdivision and the $300,000 signal. That's a key part of takings law in certainly Washington jurisprudence. Other than takings, you can get into trouble under the Constitution through depriving a person of their procedural due process. If you rezone land without providing notice that you're rezoning land, if you hold hearings without telling people that you're holding hearings, those are deprivations of due process. You can deprive someone of what's called substantive due process if your permitting or your planning decision is completely unhinged from reality. If it's just something you have made up as you've gone along. And it sounds funny, but truly, if your planning decision making isn't the outgrowth of a logical record, it can be so arbitrary that it's a deprivation of substantive due process. And if it's just so vague that nobody knows what it means, that can be a due process violation. Occasionally, you get into planning or permitting decision making that's a violation of the Equal Protection Clause. If your planning or permitting classifies people by race or gender or national origin, you may very well have violated the Equal Protection. It doesn't happen frequently, but it can happen. And the First Amendment is very much alive and well in areas of free expression of religion, free expression of speech. Churches, strip clubs, adult-oriented businesses are certainly vigorous defenders of the First Amendment. Well, One of the reasons that I spent some time on the constitutional dimension of this is to convey the seriousness of the planning or the permitting activities that you folks engage in. These are constitutional considerations. These are real, legitimate civil rights concerns. Now, they're not civil rights concerns like Selma, Alabama, but they are civil rights concerns in the sense that they can be the deprivation of a protected property interest that can trigger liability under the Civil Rights Act. So in addition to Washington's RCW 6440, we're also talking about activities that trigger liability potentially under 42 U.S.C. 1983, the Civil Rights Act. It's that serious, folks. There's a great quote. I think Justice Brennan says in a decision, "We expect police officers to know the Constitution. Why not planners?" He's right. He's right. Okay. So we're going to shift now off the Constitution a little bit, and we're going to get a little more into economic development. But I want to use the phrase economic development deliberately. And I want to get to a point where I'm talking about economic development in relationship to planning. So to do that, I first want to talk a little bit about economic development as a development program concept. There is in Washington law a very short, I mean a 2-sentence statute, miracle of miracles, a 2-sentence statute. The legislature said everything I needed to say in 2 sentences. There's a statute, RCW 3521-703, that says that in essence economic development is a proper purpose of local government. That's all it says, though. What does it mean? We don't really know, but we know that it can override the Constitution, and the Constitution, the Washington Constitution, makes it very difficult for local government to engage in economic development per se. That means, in other words, you can't use local government to funnel monies for economic development purposes just because you would like to see public resources used to promote the greater economic good. That's exactly what you can't do. Now, there are footnotes to that, but for the most part, public grants to private interests are unconstitutional unless you're King County and you really like baseball. The very few exceptions. Very few exceptions. Otherwise, you have to establish that your economic development goal is a fundamental purpose of government. And you can do that sometimes. That's out there. It's possible. I'll tell you a case. I was involved in a matter 4 or 5 years ago where a jurisdiction realized that it had a junkyard in the middle of a river that was constantly leaking all kinds of hazardous contaminants, not just into the river, but into the zone where the river and the groundwater interact. So it's a bad problem. And this particular jurisdiction had what's called a flood control protection zone, flood control hazard zone. I can't remember. It's a special purpose district authorized by Washington law. It was a branch of the jurisdiction itself. It wasn't a private organization. I can't come up with the name of it. Anyway, this flood control zoning district, there we go. Flood control zoning district says, here's what we're going to do. We can't afford to condemn the junkyard. We just don't have the money. But what we're going to do is we're going to buy the junkyard owner a piece of ground up high out of the flood control zone, and we're going to pay then to relocate his crusher, his Hulk vehicles, everything that he's got. We're going to pay to relocate that from the island in the river. And of course there was a bridge to the island. You know, it was a pretty moderately capitalized business. We're going to pay to relocate it from there to the upland area, and we're going to ask him to sign on and accommodate this, make it happen. Well, that jurisdiction got sued by people who didn't want the new junkyard right next to him. Okay, not too shocking. But you can't just say, I don't want a junkyard next to me. You've got to have a basis for the lawsuit. And they used the concept that jurisdiction had gone beyond the Constitution. That jurisdiction had bought a new location. It had paid to move this person's facility from the old spot to the new spot. It had set them up in business in a much more desirable location. Well, the complaint was, why didn't you just shut them down? Why didn't you just enforce the code? So it becomes a lawsuit. And because the court accepted that the fundamental interest of the flood control zone district was being furthered, it succeeded. It was not held unconstitutional. But it was a pretty significant case. It went to the Court of Appeals. It almost went to the Supreme Court. And so the point is that these things really matter, and they really do impose constraints on how far local government can go. This is not Texas, where local communities can actually take out loans to promote economic development. No loans being issued to the city of Fife to spend money on economic development, for better or worse. In fact, Washington is one of the most restrictive states, limiting this kind of economic development as a conduit from the public to private enterprise. The questions remain, is it a fundamental purpose of government? A corollary to that is, was there adequate consideration? I don't mean to scare everybody into the view that local government can't be a player in economic activity. That's certainly not what I'm saying. You can, in a contract sense, if there's an exchange being made. If it's not the flow of capital with no return, but you're getting something back in response. The legal test is if you're getting anything at all, more than a peppercorn in return, then your jurisdiction engaging in some kind of contractual relationship is not going to be violating this constitutional provision. You know, there is this idea that a peppercorn, the idea is it's just the smallest little thing. If you get the smallest little thing in exchange, you're good. Okay, I want to shift from development programs. I told you what I want to talk about was planning. I'm not an economic development person. I'm not even a planner. I'm a dabbler. That's what lawyers do. But I do more planning law than I do economic development law by a far shot. So my main thesis is that good planning is economic development. And I want to talk about good planning. Why is good planning economic development? Well, Maury's made it easy on me to a great extent. Good planning is economic development because it does things that lay the foundation for everything Maury talked about. Good planning helps establish the proper supply and demand of land inventories. You know, there's an economic development prong in the Growth Management Act. Not every jurisdiction has implemented it. I don't think jurisdictions are required to implement it right now, but it's certainly a premise of GMA that economic development is a goal of planning. It's a goal of coordinated planning. It's a goal of long-range planning. Providing infrastructure and capital facilities. How are you going to get economic development if you haven't thought about how you're going to extend sewer and water? Where are you going to extend sewer and water? To places that have no economic development potential whatsoever? Well, of course not. How about to places where you want to guide economic development? That's planning. That's economic development. Essential public facilities are a key part of economic development. Are you going to take steps to protect your airport from encroaching incompatible use? An airport's an essential public facility. So is a hospital. So is a prison. Some of these more attractive than others. But the idea is that in planning, deliberately, you get to make these choices. And if you're informed by the kind of considerations that Maury has given you, then planning really is a tool for economic development. Other planning goals that can work with economic development include the very idea of visioning through your comprehensive plan effort. I know I'm talking to a lot of planning commissioners. I hope I'm getting some traction here. You know, what does Fife want? We heard a little bit of that from Dave. Does it want growth? What kind of growth does it want? That's got to be thought through, and then you've got to think about how to implement it. You've got to have a recognition of the importance of coordination and consistency in planning. Now, here's where we really hit the minor key. Because if you're going to talk, this is where we go from the Paul McCartney Beatles. We're now in some George Harrison, dark, gloomy, you know, this is where it gets a little bit tougher. the importance of coordination and consistency in planning often runs headlong into a problem. The problem is the discipline, the need for discipline of coordination and consistency in planning relative to the challenges presented by opportunistic decision-making in permitting. Okay? Do people have a sense of the difference between planning and permitting? Yes, no, I'm thinking of a Beatles song I can't get out of my head. Okay, here's what I want to get across as the difference. Planning is this really broad community visioning concept. Okay, planning commissioners, very familiar with planning ideas. Permitting is where the rubber hits the road. Planners, planning professionals, long-range planners, those folks, very familiar with permitting. So if you got the big top of the funnel is the community view through comprehensive planning, through planning commission efforts, neighborhood plans, sub-area plans, that kind of thing. And then it gets a little more constricted, and it gets down at its narrowest part where you're doing permitting. Permitting is the quasi-judicial action that will wind up getting you in hot water if you don't reflect on all that constitutional stuff I talked to you about before. Permitting is a key part of economic development because if your permitting goes awry, you've lost the community's credibility for planning purposes. And now you've made it hard to do any of the fun stuff that Maury talks about. So we're going to talk a little bit about permitting. Project permit procedures are a key to promoting this goodwill of the community. They're a key to avoiding lawsuits, and frankly, they're a key to allowing you to do economic development without having to cut through rampant public opposition to everything you may want to do simply because you may want to do it. Communities vary on this widely. There are communities that I've been involved in cases for who can't succeed in planning anything, I mean almost anything, because the permitting has gone so wrong on maybe one big case or maybe a series of cases that the public's lost confidence. They don't trust anybody that has a planning role, a planner, a planning commission member. It oftentimes bleeds over into city councils and county commissions. You don't want to have that happen because you can't easily regain it. It takes generations almost. Well, why is that? Why is it that bad permit decision-making can be such a hairball of a problem? Why is it so hard once you get into that to get back to a baseline? Well, the answer is because land use cases are different. Okay, different from what? Well, they're different from nearly anything else. How about that for a tautology? They're different from the way you may solve problems in your own business. They're different from how you may do other aspects of the city's business. They're certainly different from other kinds of lawsuits. Well, it's because land use planning relates to specific pieces of ground, and people feel really strongly about their specific pieces of ground. They're different because these things are often done with the parties pretty entrenched, a developer perhaps, and then an opposition group maybe pretty entrenched. And both of those parties may jockey their decision or their review of your decision making in consideration of what's going to happen in court later. They may be thinking about how they are going to do better or worse relative to what they think they can get a judge to do. And that's not how you want people thinking. These things are difficult because it can be really hard to compromise once those positions get entrenched. People have very different visions, very different views of what a land use dispute even is, or how it's supposed to be solved. Sometimes people become very convinced that this land use dispute reflects something rotten in government, and it reflects something that just permeates their relationship to their local officials. Other times, perhaps the developer may think, gosh, we just got to make a business decision. We just got to figure out a way to get out of this dilemma. But there's no mutuality of that view necessarily. And so it becomes very difficult for a local jurisdiction that has its own constraints to be a deal maker. That local jurisdiction is stuck with limited resources, sometimes dramatically fewer resources than what either the opposition group or perhaps the developer can bring to bear. And the local decision making it's complicated. You know, on Facebook, there's a little, I'm not a Facebook user, but I've looked over my wife's shoulder once or twice. Yeah, you could define your relationship status. You say single, married, or it's complicated. I don't know exactly what that means, but land use decision making, when things go awry, it gets really complicated. Well, why? Because it's political. It's not supposed to be, but it becomes political. All right. I've hit on this slide largely already, but I want to touch on it briefly here. The other reason is that it's very difficult to solve these cases. Once you're wrapped around the axle, what really begins to happen? Well, the media begins to get involved. The statements that get made tend to escalate. Every statement's got to become the biggest, most profound statement on the case, and it just really augurs in. And you don't often have a safe harbor. You've got a problem in which if you zig one way, you're going to make one constituency unhappy, and if you zag the other way, you're going to make the other constituency unhappy. Okay, let's dig out. Let's get out of this mess a little bit. What can you do about this? Well, one thing you can do is you can identify stages of these kinds of problems. Planning, I hope I've already conveyed this, planning tends to be pretty friendly. If it's done right, if you really do involve the community, if you really do have a sense of the leadership importance of good planning, then you'll find that the process of going through permitting is much smoother, and you maybe don't have to worry about the legal and administrative appeals. If you really deliberately try to get people involved in planning through having meetings and feedback opportunities, if you create stakeholder groups where you don't have one stakeholder meeting hidden in a basement conference room and then declare that you've acquired consensus, but you really have stakeholder meetings where people are allowed to provide input, and then you bounce the input back out to them and force them to respond to the input that they really didn't give in the first place, but now they've got a chance to respond to it after all. Well, that's giving chances for resolution of permit disputes that may never even happen in the first place. Ad hocery is not a word. I've used it here, however, because I think you know what I mean. The idea of results-oriented decision-making, doesn't that, it sounds pretty attractive, right? We want to get a good result. Well, I'll tell you what, though, the problem with results-oriented decision-making is that it implies that the result is sufficient to justify some kind of bending of the rules to get the result. It implies manipulation of the law to obtain a preconceived result, or it implies that legal consistency is not valued as much as a certain outcome. You don't want results-oriented decision-making when you get to a permitting level. You want to have principled decision-making and let the results fall where they fall. If your planning makes sense, then your permitting should make sense if you follow the law meticulously. Why do we care about this exactly? Why do we care about this? Because this is how judges think. Okay? This is what judges don't want to be told that they made a results-oriented decision. They want to be told that they applied the law fairly. And that's what they will expect of planning commissioners or city council members if you get sued. Okay. A couple of practical solutions, and I'm going to wind up here. I'm going to pick on the second bullet point here. It really is useful. It really is indispensable, in fact. I think most folks understand the board-staff relationship. It really is important, though, to have a willingness to formally comply with rules and procedures. There is no gain in being relaxed and casual and informal about the appearance of fairness doctrine or the Open Public Meetings Act. It's not an area to dabble. You got to know. If you're going to know that, then you've really got to spot the issues, and you've really got to force them to be resolved. To be a little more specific, it helps if you have a principled view of the decision-making process. if you really insist on fairness, and if your findings are in writing, and if they focus on the actual facts in the hearing room, not what you came into the hearing room with in your head, but what actually came into evidence in the hearing room. If you emphasize that and you have this in writing, a judge will see that you weren't results-oriented, but that you were faithful to the code. Okay, a couple of last ones here, and these are really going to be aimed primarily at the planners and not necessarily the members of boards and committees. It really is valuable from time to time to pause and consider how effectively your local code lets you do your job. Two areas that just come up again and again in my practice have to do with SEPA and appeal processes. If your appeal processes aren't clearly defined, you're just adding another layer of problems. You're taking three-dimensional checkers and you're doing three-dimensional checkers upside down underwater. Make sure that you've got a sense of how your local development permit appeal process is run. As to SEPA, the main thing I emphasize, SEPA is the best tool that you've got at a permitting level, and to some extent at a planning level, but it's the best tool you've got at a permitting level to understand what you're doing and what the consequences of it are, and then to be able to show your work to the community. If you do SEPA diligently, I assure you, if you handle categorical exemptions carefully, if you know what kind of threshold determination the record really supports, if you do that carefully, I assure you, you will inspire more public confidence than you'll know what to do with. If you short-circuit SEPA, you'll never get the credibility back. I very much appreciate your attention. I know some of this is a little harder slogging than Maury's freebies. I had no freebies. I guess that's clear now. The only freebie I can offer you is some free help. Department of Commerce, you know, you've come here tonight. This is a great opportunity to learn about some of these things, obviously. Patty's already done the plug for WCIA. I can't say enough about that organization. And for members of WCIA, take her at her word. It is a fantastic organization for getting legal help down to communities that otherwise might not have accessed it. And good old MRSC, what would we do without them? Thanks again so much. I appreciate it all.
Thank you very much.